All right, ladies and gentlemen, good afternoon. My name is Stan Gunter, and this is my first meeting as chair in the General Assembly. And I appreciate everybody tuning in, even those that are on the Zoom with us. Getting ready to start it up, and I believe we have Representative Rob Leverett with House Bill 97, I think. Is that correct?
Yes, sir.
All right. You can go ahead and talk to us about the bill.
Thank you, Mr. Chairman. First, I want to thank the committee and administration for taking this and moving on it so quickly, getting in the subcommittee. And I want to thank you, Mr. Chairman, for calling the meeting so quickly. I really do appreciate that. I guess it's sort of famous around here to say this is a simple bill, but it is a simple bill, I believe, although it does have a little bit more of a story to it. It amends a code section in the probate court code and not in the probate code in Title 52, 53, but in the Title 15. Thank you, Representative. It amends a provision relating to probate clerks, and it just provides that the chief clerk must take an oath, and that oath must be placed on the minutes of the court. That's all this bill does. The reason it does that is because, as many of the members of this committee remember, 2 years ago, Senate Bill 436 was approved by a substitute out of this committee, passed by the House, and the Senate later agreed to those changes. And it made a number of changes in that area of Title 15, one of which addressed succession in the event of vacancy in the position of probate judge. And one of the people or offices in the line of succession is the chief clerk. If there is say a death by the judge or an otherwise vacancy created, then the associate judge or the senior associate judge, if there is one, would assume the duties of the clerk on an interim basis until a special election can be held, or depending upon when the vacancy occurs, until the term expires and the regular election is held. If not an associate judge, then it's the chief deputy clerk. And if not that, then the Superior Court judge would appoint someone. This bill just simply provides a means of confirming and creating a record as to who the chief clerk is. Because traditionally the associate judge would take an oath, and by the date of the oath, you could tell who the senior associate judge was. And this simply makes a similar requirement with respect to the chief deputy clerk. So there's no potential disagreement about who the chief deputy is. And there also, even to the extent everyone agrees, there is a written evidence of it for other purposes that the county might have, and changing salary and things of that nature.
Right. And you and I had spoken about whether the chief clerk is the clerk of the Superior Court serving as clerk in the probate court, and this addresses all that as well.
Well, to an extent it does. It doesn't address that specific situation, but the bill does say that if first of all, to ascend to the position of probate judge, the candidate or the person has to be eligible to serve in that position. And I think the situation you may have in one of your counties is that the clerk of the Superior Court serves as a clerk of the probate court. In that case, I think they would not be eligible, and it would go to the next candidate, which I think after the chief deputy, the Superior Court judge, chief judge of the Superior Court or of the circuit in which the probate court is located, would select someone. And they would just serve on an interim basis, depending upon when the vacancy occurs. If it's the last year of the term, they would serve the rest of the term. If it's before that point, there's a special election called.
Okay. All right. I believe we have a question over here.
Yes.
Representative Reeves.
Thank you, Mr. Chairman. I have two questions. Representative Leverett, the co-sponsors that you get on a bill oftentimes says a lot about the bill. And I see that Representative Scoggins has co-signed this bill or co-sponsored it. What makes you think that he knows anything about this?
I'm told by reputable sources that he was a probate judge at one point in his checkered past, and so I'm assuming he has some recollection of that.
Good answer, and which leads me to my serious question. Did the Council of Probate Judges work with you on this?
Well, I don't know that the council did, Representative, but it was requested by a representative of that council, is my understanding.
Okay, and is the probate judges, are they going to do they have anything to opine in the committee today on this, or I'm just curious what their thoughts are?
I would say my understanding is was requested by.
Okay.
All right, any other questions? Anybody on Zoom? No? Okay. All right, well, are we ready to make a motion? Second? Motion and second? All those in favor, say aye.
Aye.
Any opposed? And we'll give Zoom a little time, make sure we get everybody. That guy?
Way too easy on these new people.
All right. All right, then it's passed to the full committee.
Thank you, members of the committee. Thank you, Mr. Chairman. And I appreciate the easy too.
All right. Thank you, Representative Leverett. All right, next will be House Bill 90. And, okay.
Good afternoon, Mr. Chairman, members of the committee. I was thrilled to hear that word easy just then. Because I shared with Chairman Estration yesterday that I'm going to my 11th session, and I have studiously, intentionally, and with every effort I could muster every year, tried to avoid the Judiciary Committee. Yet here I am in front of these learned people, and the only thing that I can say now is I thought that was my worst fear, but now I'm a little bit worried that y'all might be sending me bills for your time. As a business owner, that's all I've ever experienced. So that being said, what I'm bringing before the committee today is, in all honesty, I just assumed it'd go to the banking committee, because what this bill's attempting to do is clarify the relationship between the UCC and in this language that goes back to timber theft and torts, is dealing with severed timber that's owned by property owners. So the whole, and what we're dealing with is basically a 1939 law moving forward. I think it was in 2001, it's the latest iteration of the Uniform Commercial Code. But since 1939, the whole timber industry's changed drastically. Mills nowadays, as most of you might know, buy their timber at the gate. It's typically, you have timber dealers that will go cut deals with timber property owners, and they will shop they will get the best price they can from a landowner, knowing that they can get a profit by selling this part of the load to one mill and this part of the load to another mill, depending on what the mill's needs are. But mills are typically paying by the ton, and all the timber cutter has to do is deliver the size logs that they're pre-agreed on in a certain amount of weight for which they're paid. So when the mill hits the gate, it's called gate wood. It's just a commodity. And this, the need to get clarity on this arises from a situation that happened in South Georgia, where he basically had a timber dealer that had borrowed a lot of money, and in the bank involved decided that they could go after the mills that had purchased this wood, large mills, I think from small to large mills. And they didn't know what they were talking about when all of a sudden they get these demand letters about the fact that this land had security liens on it. So that being said, and the fact that I am in front of a Judiciary Committee, I'd like to introduce Ivy Cadle, who's a practicing lawyer that's going to help us walk through the bill. So if you don't mind, I'd like for him to help present the bill.
That mic, and which number is that on here? What number mic is that? That is number 4. There you go.
Cool. Thank you.
And please introduce yourself.
My name is Ivy Cadle. I'm an attorney at the law firm Baker Donaldson, and I represent one of the timber mills in the dispute with the bank. And just like he said, this came to everybody's attention because there's a 1939 tort statute that sets out, it's really two-part statute. 511250 says if I just go cut his timber, I get treble, or he gets treble damages because I just went and cut his timber and did him wrong. And you ought to be able to go survey your boundary line. You ought not be cutting other people's timber, so you get treble damages. 511251 protects someone who has a security interest in his timber. So it says to the extent there's indebtedness on the timber, the holder of the security interest can go after the wrongdoer who cut the timber. And so what the way this dispute arose and the way this needs clarification, I will say very plainly, it's our position that the 2001 provisions of the UCC with logs being treated as goods control this situation. The plain language of the UCC is just that, very plain. And all we're trying to do is correct a 1939 statute so that it's very obvious on its face that the UCC controls, and you don't have to go do a bunch of research to figure that out. So what we have done really is just insert language that puts the buyer in the ordinary course language of the UCC in the tort statute. And so if you look down, the major change here is kind of down at the bottom of paragraph A. And it just says a person, firm, or corporation who purchases or otherwise acquires such timber after it's been separated from the land is a buyer in the ordinary course and shall have no liability under this code section. So that's really the main thing it does is it says it just recognizes in this statutory section that, oh, wait, we passed something 40 or 50 years later. And if you've got that situation, you need to go look there. The other thing that it does is it clarifies the 511250 that provides for treble damages does not apply if you're the holder of a security interest. You get value up to whatever you had lent. And so that's kind of the big picture. If somebody's got questions, I'm happy to answer them.
I believe we have one over here.
Yes.
Representative Reeves.
Thank you, Ivy, for being here. When did we go through young leadership, young lawyers?
I'd rather not admit.
2008.
I'd rather not admit on the record, Representative Reeves.
It's been a long time, but Ivy is a great lawyer. I'm trying to wrap my mind around this. What's an example of, and you may have already done this, but just for clarity, what's an example of a scenario or hypothetical of somebody who would not be a buyer in ordinary course? Thus, they would be subject to the tort law as opposed to the UCC. What would be a hypothetical there?
So if you had some sort of sham deal where you had an effort by LLC that was owned by the timber harvester who then tried to sell it to another LLC also controlled by the timber harvester, I think you could pierce that argument that the two LLCs were some kind of buyer in the ordinary course.
So what happened? I think
Sure.
you said there was a case against a mill and a bank. What happened that brought I understand this is to clarify the reference to the UCC, but what happened in
Sure.
that case that kind of brought all this about?
Representative Reeves, the kind of the facts that brought this to light, like Representative Reeves said, if you in modern timber practice, you're going to have an owner of property. The owner of property then desires to sell their trees. They're going to go shop the trees, which are real property at the time they're on the stump. The owner is going to go shop that parcel to a number of brokers in an effort to get the highest price for their trees as they stand in the woods. The broker is going to then typically will buy the trees. They'll get a timber deed or timber warranty deed that merely conveys the real property interest in the trees and accepts the land from the legal description. So, and if they're, so they're going to sell, the property owner is going to sell to broker. Broker and if there's a deed to secure debt on the trees, that's part of the kind of the master deed, that's going to be the owner's obligation, then the owner's bank is going to need to give a release, obviously, before the broker can actually get their interest in the trees.
Okay.
So the broker, the timber broker, will then often finance, they'll borrow money from a bank to give them the working capital to hold the trees, give them time to cut the trees, and then sell the trees to a purchaser of logs, some kind of timber mill. And so under existing Georgia law, when the broker severs the trees from the stump, they become goods. And then when they sell those goods to the mill can take those goods, because they're goods and under the timber exception to the UCC, to the farm products in the UCC, the mill can take those free of a known security interest, as so long as they're purchaser in ordinary course. And so that's kind of the hypothetical. That's what happened here. Is that the broker, the timber broker who gave a deed to secure debt and who had a UCC financing statement failed to pay the bank with the funds that they received from the logs. And so the Forestry Association and the bankers got together and said, this is a problem. Like, this is not how, if we allow this argument to remain in the public domain, it's going to increase the cost of doing business for everybody. And so how do we get it so that we can make sure that the statutes are really properly cross-referenced, so that we know if you've got a wrongdoer who is out cutting somebody else's timber and there's a loan, the bank still has all of their remedies. That's definitely something we talked about. And then if you've got a normal situation where you got a logger who's got, a logging operation, and they're buying timber and they're cutting timber and then they're selling it to a mill, the mill can conduct business as usual. Because once you get a load of logs, not like these things got some kind of radio frequency ID and you can track them all over the place. Sure. They get hauled to and if one mill closes down for the day because they got more logs of one size than they need, this gives the broker the flexibility to haul them somewhere else. And so this clarification, it makes business more efficient. It's good for business. We've kind of put it together with the bankers, and that's why we're here today.
Okay. Thank you. That helps me a lot. So, thank you.
All right. And Chairman Estration.
Thank you, Mr. Chairman. I want to begin by thanking my friend from Macon, from Coleman Hill, Macon, for being here today. Maybe first time testifying before the Judiciary Committee. Is that right,
It is,
Ivy?
Representative Estration.
We are honored to have you, and hopefully, Representative Williamson, you are reassured that Bill's no reason for terror when you typically when you come before the Judiciary Committee. But really appreciate your explanation, and you really were getting at there what I was about to ask you about from your interaction, both to the sponsor and to you, Ivy. Any concern or objections that have been raised by any groups that are affiliated here at the Capitol about House Bill 90 or the potential impact if this were to be passed this session?
So I've asked those questions, and obviously the only interested parties I could think about is the industry that brought the bill to me, the forest products industry, the mills that are gotten caught in this, the Georgia Bankers Association, and actually the trial bar, specifically the Trial Attorneys Association, and they are good with the bill. They have voiced no objection about it at all. So I've tried to run the traps on it, if you will, to make sure that I'm not that on sound ground. The only point of sort of an exclamation point on this testimony I'd like to add too is it's my understanding that some of these larger mills can literally receive 1,000 trucks a day of gate wood. And just like Ivy mentioned, Some of it might need to be diverted. One timber contract could be 1,000 acres of trees, some of which is hardwood, various sizes of the pine, everything from saw timber all the way down to, chip and saw and all the way down to the pulp stuff, the small stuff that goes to make paper. Well, some of this hardwood actually goes in advanced materials. For example, Rayonier down in Jessup, Georgia, is the economic engine of that whole county. Is that Wayne County? Is that right? It's a huge economic engine of Southeast Georgia, and it would severely cripple their whole operation if they had to do all this extra steps just to make sure the product hitting their mill door or gates every day. So it's really a job security issue right now, having had this instance arise where a very smart attorney found this little bit of ambiguity that they were able to, doing their job, trying to get some money back from a lending institution that had basically been conned. That's just in my layman's language, the best way I can put it. So I'm happy to answer any other questions, run any more homework that the committee might want, and obviously asking for y'all's favorable consideration. If there's a possibility of moving on to full committee, that'd be fabulous, but I'm happy to follow up anything you have.
Thank you.
All right, and Representative Evans.
Thank you, Mr. Chairman. And there's so much Ivy Cato love going around this table. I knew him first.
You did. You did.
Because we were at Georgia together, so I'm
Yep.
sure I have the best stories and probably vice versa. My one concern I have is in lines 29 to 30. It sounds like the way it was presented, we're looking to limit liability for the buyers in the ordinary course. But to me, this seems to take any teeth out of this section with regard to anybody, and nobody's going to be subject to damages. And I wondered if you could just address that, or
trying
maybe
to
somebody
find
on the
my
committee
copy.
can correct
I think
me.
I gave you my copy. That's
I'm
got the
sorry.
line numbers on it.
Yeah, so there's my notes.
Thank you. Well, give me those lines again.
29 and 30.
So that's a great question. So, and I tried to set that up, maybe I wasn't clear. So OCGA 511250 provides when I was kind of putting all this together, I read most of the Georgia Tort Code because I wanted to figure out what human actions would give rise to liability under 511250 and 511251. If you go up, and I got it somewhere in my notes, but the section, there's a section on like just wrong acts taken out without a legal right. And it's like way on up in 51, like one up in the definitions. And it talks about different kinds of things that you can do that are with unlawful acts against somebody else. And it says basically, if there's an instance where someone cuts the trees of another, then the damages for that cause of action are specified in 511250. And I hope I'm answering your question. So 511250, which we don't have in front of us, but it just simply says if an individual or entity goes and cuts the trees of another, then they get treble damages. And there's no great statutory language as it exists. It's kind of inferred, but there's no great statutory language right now that says if you have a cause of action under 511250, or excuse me, if you have a cause of action under 511251, the one we seek to change, then you can't also get treble damages. Because the way I read it, 511251 that we seek to change, the purpose of this statute is to let the bank have an independent cause of action against the individual who cut the trees so that they can recover however much money they're out because their collateral was taken. 511250 lets the person whose trees got cut go seek treble damages. So the property owner is entitled to greater damages than the holder of the security interest. In other words, the property owner has more protection than the lender.
What would the measure of damages be for a violation of
Up to,
this current one that we're
for the
working on?
value of such trees,
And that's in here.
it's on line 20. So line 20 is, you get any trees growing on such land, I'm starting on 17, shall be
Mhm.
liable to the holder of legal title for such trees, legal title being a lender, for such trees in any form, laundry list of stuff, down to line 19, or otherwise converted by such person, firm, or corporation for the value of such trees, provided that the recovery may not be more than the unpaid portion of the secured indebtedness. So if you're a lender, you get the value of the trees. If you're an owner, you can get treble damages. And so I think in a simple situation where, let's just say I'm a citizen unburdened by concern about boundary lines,
Mhm.
and I want to sell my timber and I own it free and clear, and I hire somebody to come cut the timber and I swerve off onto his property by 100 acres, then he can sue me for 3 times what those 100 acres are worth.
Mhm.
The bank, his bank could join in, and then they could recover against me in an amount not to exceed the unpaid portion of their secured indebtedness. And I would imagine the bank would get 1/3 and then he'd get 2/3 of treble damages. It's kind of the way I see that working out.
If I could have one more,
Go ahead.
Mr. Chairman. I pulled up 51-1250, and I thank you for that. That clarifies it in my head very well. But 51-1250 starts off by saying, except as provided in 51-1251, which is what we're dealing with, where a plaintiff recovers for timber cut and carried away. This is the measure of damages. So if you have further reason why you think we need this, I'd love to hear it. But otherwise, I'm thinking that we're stepping on ourselves here with this, and that it wouldn't be necessary.
Let me pull it up. Well, the reason we added that and the reason the bankers agreed to add that is because despite the existing language of 51-1250, which is very plain, we're encountering arguments that somehow a lending entity would be entitled to damages
Mhm.
both ways.
Okay.
And so we're trying to make it just painfully clear that you get one or the other, but not both. If
Gotcha.
you're a lender.
Okay.
What if you're both owner and lender?
That'd be interesting. I guess you could file under both, though. You'd have two different, I mean, the only way I see that playing out though is you'd have loaned money to yourself. So you'd get treble damages. But the whole thing in my mind is limited to treble damages for the cutting and damaging of trees. And then 51-1251 exists in case for some reason the owner of the trees doesn't bring an action under 51-1250 and the holder of the secured interest wants to bring their own independent action under 51-1251.
So it's either or.
That's, I mean, yeah.
Okay. Any other questions? What number are you?
7.
Go ahead.
Thank you, Mr. Chairman. My question, the only one I just ask is there pending litigation right now, or or has that been resolved?
There is no litigation that has been filed at this moment.
Okay, so no pending.
Not at this moment
Okay.
that I'm aware of. Just to be as candid as I can be.
Okay.
I don't know if Representative Kelly's getting to a retroactive effect. Is that what you're thinking about?
I think just traditionally we've had a habit of not passing legislation that would impact a case that had currently been filed. That's kind of just been a tradition not to interfere the legislature into the middle of a court case.
From the industry perspective, we'd like the legislature to move on this so that it's clear going forward, and that the bankers and the Georgia Foresters have clarity going forward That's the, so, because we can't control when this lawsuit might arise or when the next one might arise.
It's not my intention to try and slow it down today.
Thank you.
I would just, before we get to full, I'd like to just know for sure.
Mr. Chairman, I'm assuming that there'd be a July 1st effective date, given the fact that we don't have any other requested effective date. Y'all, you correct me if I'm wrong on that.
As long as things continue on the,
Yeah, well, I'm sorry,
Yeah.
yeah. Pandemic notwithstanding.
All right, and Representative Evans.
Thank you, Mr. Chair. I apologize for piping in, but Representative Kelly motivated me. You mentioned that someone, despite the language of 51-1250 saying except as provided by, but that people were still making arguments that they were entitled to it following this code section that we're trying to change. So in what forum were those arguments made if there's not pending litigation? Is there,
Pre-threatened litigation mediation.
okay. So there's mediation, not arbitration and not litigation.
There has been a mediation.
Okay.
There's currently no suit filed. They may have filed it today. I don't know about it.
Okay.
That's where we're at. So there's been a discussion among the parties about what to do. There have been letters, that have exchanged, demands that have been exchanged. But the participants the litigation participants, the parties, have consulted the trade groups who have then, so Georgia Forestry Association as a whole, and then Georgia Bankers Association as a whole. And I was part of discussions where leadership from both were on calls saying that, this is what we were willing to do now, regardless of whatever happens with this other situation.
Gotcha. Thanks.
All right, Representative Oliver.
I was distracted by trying to remember what we had done to 51-1250, and we did amend that in 2014, but that's not in any way related to today. The tradition of not passing legislation in the middle of litigation is one that I've generally felt was the right policy, but it's not been consistent. I've personally been inconsistent about that.
Mhm.
I think the purpose of that policy is not to pass a law for the have group when the have not group doesn't even know where to be. And we've done that here. We've decided who's going to win this big lawsuit because didn't tell the loser in that contest what we were doing. But what you're telling me is that this is a visible big versus big, essentially conflict right now.
Well, the big versus big have brought you this solution to future conflicts.
Right.
Within big versus big, there are subdivisions, smaller players who are potentially involved in this one known conflict.
And that matters to me in terms of whether we look at how we look at this tradition. Who is not at this table who is interested in this issue that we're kind of taking another track around the courthouse for? And I can't answer that question because the tradition of deciding who's going to win this lawsuit is or is not what we're doing right in some sense. And that's the conversation I'm having with myself. And so I just wanted to tell the benefit of the newer people here about this tradition of not deciding who's going to win the lawsuit.
Right. Seems that it's more it helps the landowner and the lender. It's the broker that's the one, if anything happens here, would be harmed by it. That's who we're talking about. Okay.
I want to protect the landowner who's entitled to his treble damages based on based on what we did a few years ago.
Yeah.
Intentional bad doing.
If I'm hearing this right, that it does.
We
that.
have no intention of disturbing that whatsoever.
Yeah, would 100% concur with
Yeah.
you, Representative Oliver. That it's my understanding that it doesn't affect that at all. And I kind of want to go back to the fact that this would greatly disrupt the business of these very important, job providers. Be it there's a new handful of mills spread primarily, through South Georgia where jobs are very scarce, that it can severely impact their ability to do business if this became a recurring problem. And I want to clarify, as the best of my understanding, it's one bad borrower that caused this whole situation. It was so the bank didn't do a great job of underwriting the character on the loan.
Any other questions on Zoom maybe, or no? Any other questions here in the room? All right, ready to, we'll see. I think I have another witness. So, thank you, gentlemen. And we'll call in Ms. Chandler.
Okay. No, I'm excused too, right? Okay.
Yes.
Okay.
Good afternoon,
Good afternoon, Ms. Chandler.
Mr. Chairman and members of the committee. I'm Elizabeth Chandler with the Georgia Bankers Association, and I just wanted to briefly underscore what Representative Williamson said and what Ivy Cadle said about our involvement in this solution. And the folks that we had at the table agree that this appropriately addresses the intent of the parties to align the tort statute with the Georgia UCC and protect the good faith buyers in the ordinary course.
All right. Any questions? No, nothing on Zoom. All right, Ms. Chandler, thank you very much.
Thank you.
And I believe that's all the witnesses.
Motion at the appropriate time, Mr. Chairman.
All right, I'll take that motion.
Motion do pass.
Is there a second?
Second.
Second. All right. Any further discussion? Also, Representative Evans.
Thank you. I support the bill and certainly want to make sure we protect the landowners. And I'm not even sure I would want to propose an amendment to delete 29 to 30, but I thought it was worth a deliberate discussion as a committee about it, because it is setting out that the measure of damages in 51 is different than 50 is something this body's already done. And I trust our judges to read the law and know that. And I just don't know that we need two things that say the same thing, because then somebody's going to try to argue that one means something extra. That's my concern as having been somebody, as a lot of us have, trying to juxtapose two code sections. I just have concerns that we're trying to do too much with lines 29 and 30. And if it's not the will of the committee, it's not, but I wanted to raise the issue.
All right. Thank you. Representative Reeves.
Thank you, Mr. Chairman. I don't know if we need Mr. Cadle to come back in here, but my question, and this very well may have been answered, I don't think it was, but I would like a distinct explanation on if those two lines were struck from this piece of legislation, how would that impact the policy from his perspective? So I don't know if okay. Mr. Cadle, we're discussing lines 29 through 30. Representative Evans had brought it up, and my question that, and if you answered this already, then I apologize, but I need it explained again. But what would happen to this? How would this legislation and thus policy be altered one way or the other if lines 29 and 30 were struck from the bill? Then tell us what that would do in effect to what this bill is attempting to do. Is that the right? Do you think that's the right way to phrase that?
Yeah.
Okay.
Like lines 29 and 30 are more specific than the language of 511250. So 511250, let me go back.
And I've got it pulled up right here,
Yeah,
511250.
I got it here too. So in my mind, 511250 is, I guess, arguably, and the arguments I'm here being made is that it's ambiguous because it's except where whoever's suing is going to be the plaintiff, right? Either the bank suing on the lost value of the
Or the
security
property
or the property owner, both plaintiffs. And so since it's not, the argument is, well, I'm the plaintiff, so I get to sue under one or the other, or both. And so the goal with lines 29 and 30 is to show very plainly that if you're the plaintiff under 511250, then you're not the plaintiff under 511251 and vice versa. And so when I was presented, like, except is provided in 511251 where plaintiff recovers, the measure shall be, we think it is more plain. It just very simply says, if you get one, you don't get the other. And in an effort to not have unintended consequences, instead of trying to change 511250 and 511251, we just simply said, we added lines 29 and 30 because they make it abundantly clear and don't conflict with anything in 511250.
So really it's it's obviously a clarity issue so that a judge doesn't have to decide, but it's also a policy issue that is dictating that a judge could not decide that someone could pursue a cause of action under 50 and 51, right?
Correct.
Okay.
Yes, Representative.
So I guess the way I see it is it's clarifying whether or not that's what the policy is of the General Assembly with this. And I think that's probably the right issue to discuss.
Chairman Administration.
Thank you, Mr. Chairman. As I read 511250 and I see here the language in line 30 is measure of damages. Then when I look at 511250, I see very clearly the measure of damages that are specified in that statute. To me, just in my simplistic reading of that, I don't see any inherent conflict on its face. And another way to maybe do this would be, rather than 29 and 30, we would state something to the effect of, any cause of action shall only be eligible for a measure of damages as follows. And then you use 1, 2, 3, and 4 from 511250A. Is that fair, Ivy?
You're going to have to give me that one again.
Yeah, sure. So 511250A provides the
511250A. Yeah, all right.
Yeah, provides the 4 different measure of damages, which I think are being referenced here. And this,
Hang on. I'm sorry. I don't mean to interrupt you. You lost me though. The 4 measure of damages.
So 1 is the treble the fair market value of the trees cut as they stood. 2 is treble the diminished fair market value of any trees incidentally harmed. Does that sound right?
He's reading 50.
Okay.
511250 is what he's reading.
Which is being cited here.
Gotcha. Okay. Gotcha. I've got a 1, 2, and 3 on the version I pulled up on my iPad on 511250. That's why I asked.
And so I guess what I'm saying here is you could say any cause of action
is.
brought under this code section should not be eligible for.
Can I give me just a second? Let me get on a better. I apologize, Representative Fish. should know better than to Google a statute.
Let me use that code book. No, he can use it.
Here you go. Here's just the code.
Thank you. All right, I'm with you now. My apologies. Yes, sir.
Yeah, so I guess if if the concern from the committee is clarity, which I think is a fair point, what potentially could be done here is to just specify these 4 bases for measure of damages, which are not, which cause of action should not be eligible for those 4.
So
bases.
yes, sir. So any cause of, I'm sorry, I interrupted you.
No, is that
Any
right?
cause of action brought under this, so 29, starting at 29B, would be any cause of action brought under this code section shall not be eligible for any measure of damages that are specified, or shall not be any eligible for any of the following measures of damages. And then we list 1, 2, 3, 4 under A.
Yep.
So that's treble. That's fine.
We have to do B too, don't you? We should talk about the punitives.
Yeah, and you'd have to put punitives too.
Thank you. Yep.
Because yeah, if you're the secured lender, you get your security interest back. That's our intent.
We need to put C too, because C defines B.
Well, I think you could just say 1, 2, 3, 4, and 5 and add punitive damages to, you just have a list of 5.
The punitive damages is qualified by being a willful trespasser.
Well, you just say if you sue under 51-12-51, then you don't get punitive damages.
What's your mic number?
12.
Representative Leverett?
Thank you, Mr. Chairman. I'm Rob Leverett from Elberton. I'm sorry, I think I'm the only guy in the committee room who hasn't already known you before, so it's a pleasure to see you, sir. Is it my understanding from your earlier testimony that the intention of the participants in the business of severing wood from land and processing it and lending on it were that 50, oh Lord, now I've lost it. Hold on a second. That 51-12-50 is intended to be a measure of damages for the guy that actually owns the land where the trees were cut.
That's my understanding.
Okay.
That's the way, in reading the statutes, that's the way I take away this legislature's intent. Yes, sir.
And my understanding is that the further, I guess, agreement of the people who actually make their living doing this is that if a bank has a lien on the trees and somebody basically interferes with that lien by taking the trees away and processing them, or if the lien exists on the person who holds them once they've been severed, and the person who sells those severed trees doesn't remit to the bank has a slightly different measure of damages because they weren't growing them. They just had a lien on them at a time. And that measure is set forth in 51-12-51.
Yes.
Okay.
And I would add, so long as they're not a purchaser in the ordinary course.
Right. If they're a purchaser in a course, their liability is basically nothing, as I understand. Even if they know about the lien, if they're a purchaser in a course, they're not responsible for making sure that the broker or the timber company remits money from what they pay to the bank. That's not their responsibility.
Just like if you bought a car from a Ford plan, the dealer's Ford plan.
Right. You don't have to make sure he sends the money. Ford can't come to you and say, we need your car bill.
Right.
So there's 2 different measures of damages depending upon who the plaintiff is, which affects for the interest of the party suing.
Yes.
Because the lender's got a different interest than the owner of the dirt where the trees grew.
Yes.
Okay. So and I'm sorry, I'm probably way behind everybody. So my understanding of B is you're just making it clear that the bank who sues for interference with the lien, which is what 51-12-51 is about, doesn't get all these enhanced measures of damages that are set forth in 51-12-50.
You get the value of the trees that's specified in 51-12.
Limited by whatever your interest is.
Correct.
If he only owed you $1,000 and $20,000 worth of trees got sold and money didn't get remitted, all you get's $1,000.
Correct.
Okay. So, it didn't seem to me that B was that confusing, although I could see for any measure of damages, but it does say any measure of damages that are specified in code section 51-12-50. Is it the desire of the committee that we allow the enhanced measure of damages to the lender? So then we wouldn't want to add all those extra measures into here, would we?
I think the confusion came when you look at 51-12-50, it specifically references 51-12-51 at the beginning.
But it's got to, doesn't it? Because 51-12-51 is a different cause of action to which those rules don't apply. The measure of damages is different, depending on who the interest of the plaintiff.
I guess maybe my question would be, what would be the example, or have we seen an issue where someone has successfully gotten damages as measured in 51-12-50 while bringing a 51-12-51 claim?
We haven't seen anything on that, and I mean, as Representative Evans pointed out, it's a circular reference. It's to say, if you're riding under this piece of paper, then you don't get to play over here, and if you're riding over here, then it says you don't get over here.
Right, there are different causes of action
Yes.
for different plaintiffs. And
Yes.
So just like with any, I would think that if you're bringing a 51-12-51 claim, I don't see how any judge would ever charge the jury to award claims based on 51-12-50 with or without 29 and 30 in there.
I can see, I think the when a plaintiff recovers for timber cut and carried away, I think is where the alleged ambiguity lies. And I'm reading from 51-12-50. And so I think here's the argument that could be made is that if you're, one problem with being a lawyer is you have to start believing in your case. And so it's hard to believe in the other side. So I'm doing my best. So I don't want to sit here and repeat myself. I'm trying. I guess there's some argument to be made that if you're suing under 51, if you're a lender and you've got this specific cause of action for 51-12-51, that somehow you are the plaintiff who's recovering for timber cut and carried away. And so then you're also entitled to the enhanced damages under 51-12-50. I think that is a challenging plain language argument. I will readily concede that. But I've heard that argument made.
That the lender could claim to be the plaintiff.
Correct, because they are a plaintiff bringing a claim for trees cut and carried away. So under that plain language, we should qualify for these enhanced damages.
So it's almost like the problems in 51-12-50 and not 51-12-51 in terms of the vague definition of a plaintiff.
That could be argued. But we're trying to just change the one statute, not the two. And be respectful of the fact that 51-12-50 was updated as what recently as 2004.
Okay, I believe Representative Evans has another question.
No question, just discussion, Mr. Chairman. Two thoughts. One is if we went along the lines of Chairman Festration's language, I was going to suggest that we just say any cause of action brought under this code section shall not be eligible for reforestation costs or treble or punitive damages as specified in 51-12-50 instead of trying to list it all out. But after this further discussion, maybe we do need to deal with 511250, and you could do it by saying, except when a plaintiff under traveling under, I mean, you wouldn't say traveling under, but except when you're a plaintiff under 1251, and then 50 just goes on and does itself. So it's very clear that you don't get to be the bank or whoever you are under 51 and start trying to get the damages under 50. I do, but I just still think we're setting it up for somebody to try to figure out why we have this in two different places. It's going to create more opportunity for creative lawyers, is my point.
Anytime you change something, you create more.
All right, let me go to Representative Reeves.
Yeah, after, I mean, I don't know that I'm sold either way. I think that after kind of talking through this and going around the circle, I'm kind of come back to the point where I think that the bill is presented, I think does create some clarity, and I'm kind of getting more comfortable with what is currently in lines 29 and 30. I think that there's always the chance that, two statutes right next to each other closely, they do a little bit different, but kind of the same. I mean, I totally understand that the potential is there, but I think that, in keeping it simple, I think that the exclusion language in 2930 is pretty clear. And so I'm kind of back to where we started. I think that this might be the best way to resolve it.
Okay. Representative Leverett, did you still have a?
No, I don't.
All right. Any further? Just Chairman?
Thank you, Mr. Chairman. I just had a thought, sometimes when we have some kind of questions out there, if a bill were to move forward and Representative Evans were to provide her proposed language, say to the sponsor and some of the other members of the subcommittee here today, maybe there'd be a time to discuss that before full committee and see if there's a consensus that can be reached as to what's the best approach. And if so, to have a sub ready for full committee if necessary. And if not, we can always have that policy discussion further later. Thank you.
All right. Any further discussion? Any amendments? Hearing none. I take it we're ready to vote?
We have a motion and a second.
We have a motion and a second, yes. All right, all those in favor say aye.
Aye.
All opposed? Anybody online? We're good. All right, it passes.
Thank you, Mr. Chairman, members of the committee. It has been educational.
All right, we're adjourned.
Actually, full. I just don't